Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Health and Hospital Corporation of Marion County v. Talevski. In this case, the court considered this issue. May a plaintiff file a federal civil rights claim for violation of the Federal Nursing Home Reform Act, which was enacted under Congress's spending clause power? The case was decided on June 8, 2023. The Supreme Court held that a plaintiff may file a federal civil rights claim for violation of the Federal Nursing Home Reform Act, NNA. Justice Ketanji Brown Jackson authored the 7-2 majority opinion of the court. The court first considered whether NRA can create rights enforceable through Section 1983. Section 1983 allows private parties to sue for deprivations of any rights, privileges, or immunities secured by the Constitution and laws of the United States. The phrase "and laws," without modifiers, means that the rights at issue need not fall within a specific category, for example, civil rights, or through a specific power of Congress. The court then considered whether NRA unambiguously created a right to be enforced via Section 1983 and concluded that it does. A law unambiguously creates a right enforceable via Section 1983. The provision in question is phrased in terms of the persons benefited and contains rights-creating, individual-centric language with an unmistakable focus on the benefited class. The provisions at issue here addressing unnecessary restraint and pre-discharge notice pass that stringent test. They unambiguously confer rights on residents of nursing home facilities. Finally, the court considered whether NRA creates a comprehensive enforcement scheme that is incompatible with individual enforcement under Section 1983. While NRA does have a complex enforcement scheme, that scheme is not incompatible with individual enforcement under Section 1983, and does not suggest Congress intended to preclude Section 1983 enforcement. Justice Neil Gorsuch wrote a concurring opinion to point out two questions the petitioners could have raised but did not, and called for the resolution of those questions another time in another case. Justice Amy Coney Barrett authored a concurring opinion, in which Chief Justice John Roberts joined, cautioning that while she agreed with the disposition in this particular case, courts must tread carefully before concluding that spending clause statutes may be enforced through Section 1983. Justice Clarence Thomas authored a dissenting opinion arguing that laws passed pursuant to Congress's spending power cannot secure rights within the meaning of Section 1983. Justice Samuel Alito authored a dissenting opinion, in which Justice Thomas joined, arguing that while NRA does create individual rights, the remedial scheme of the Act forecloses enforcement of those rights via Section 1983. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. The Federal Nursing Home Reform Act, FNHRA Act, ensures that nursing homes that receive Medicaid funding respect and protect their residents' health, safety, and dignity. Provisions of the NAA refer to rights of nursing home residents to be free from unnecessary physical or chemical restraints, and to be discharged or transferred only when certain preconditions are satisfied. This case is about these particular provisions and whether nursing home residents can seek to vindicate those NFRA rights in court. Respondent Ivanka Talevski maintains that she can enforce the rights these particular NRA provisions describe via 42 U.S.C. Section 1983, which, since the 1870s, has provided an express cause of action to any person deprived, by someone acting under color of state law, of any rights secured by the Constitution and laws. Petitioners insist that respondent is wrong about being able to rely on Section 1983 in this context, for two independent reasons. First, petitioners urge us to discard our long-standing recognition that Section 1983's unqualified reference to laws means what it says, and to rule instead that Section 1983 contains an implicit carve-out for laws that Congress enacts via its spending power, a holding that, according to petitioners, would mean that Section 1983 could not be used to enforce any rights the NRA purports to recognize. In the alternative, petitioners point to our established methods for determining whether a statutory provision creates a Section 1983 enforceable right, and maintain that these NRA provisions do not create rights that nursing home residents can enforce via Section 1983. We reject both propositions. Laws means laws, no less today than in the 1870s, and nothing in petitioners' appeal to Reconstruction-era contract law shows otherwise. Consequently, as we have previously held, Section 1983 can presumptively be used to enforce unambiguously conferred federal individual rights, unless a private right of action under Section 1983 would thwart any enforcement mechanism that the rights-creating statute contains for protection of the rights it has created. We hold that the two NFRA provisions at issue here do unambiguously create Section 1983 enforceable rights, and we discern no incompatibility between private enforcement under Section 1983 and the statutory scheme that Congress has devised for the protection of those rights. Accordingly, we affirm the lower court's judgment that respondent's Section 1983 action can proceed in court. In 2016, when Georgi Talevski's dementia progressed to the point that his family members could no longer care for him, they placed him in Petitioner Valparaiso Care and Rehabilitation's (VCR) nursing home. When he entered VCR, Mr. Talevski could talk, feed himself, walk, socialize, and recognize his family. Later in 2016, however, Mr. Talevski's condition suddenly deteriorated. He became unable to eat on his own and began losing the ability to communicate in English, leaving him to rely primarily on Macedonian, his native language. VCR staff claimed this was dementia's natural progression, but Mr. Talevski's daughter suspected, and then confirmed with outside physicians, that VCR was chemically restraining Mr. Talevski with 6 powerful psychotropic medications. With the help of an outside neurologist, his medication was tapered down, and he began to regain the ability to feed himself. Around this time, the Indiana State Department of Health conducted its periodic inspection of VCR, and the Talevskis filed a formal complaint with the inspectors regarding the chemical restraints. The problems did not end there. Toward the end of 2016, VCR began asserting that Mr. Talevski was harassing female residents and staff. Based on that claim, VCR began sending Mr. Talevski to a psychiatric hospital 90 minutes away for several days at a time. VCR readmitted Mr. Talevski the first 2 times it sent him away. But the third time, instead of accepting him back, VCR tried to force his permanent transfer to a dementia facility in Indianapolis. It executed these changed circumstances without first notifying Mr. Talevski or his family. The Talevskis filed a complaint with the department regarding Mr. Talevski's forced transfer. While the complaint was pending, Mr. Talevski had to stay at another facility that was 90 minutes away from his family. Eventually, a department administrative law judge nullified VCR's attempted transfer of Mr. Talevski. Based on that determination, the Talevskis endeavored to have Mr. Talevski returned to VCR, but VCR ignored the judge's decision and refused readmission. The Talevskis complained again to the department, which later issued a report regarding the Talevskis' complaints. Subsequently, Petitioner American Senior Communities LLC, ASC, which manages VCR, contacted Mr. Talevski's wife, Ivanka, to discuss the possibility of Mr. Talevski's return. At this point, however, Mr. Talevski had acclimated to his new home, and the Talevskis feared retribution against him if he returned to VCR. So they opted to leave him in the new facility, which meant that every family visit required a 3-hour round trip. In 2019, Mr. Talevski, through Ivanka, sued VCR, ASC, and Petitioner Health and Hospital Corporation of Marion County, collectively, HHC under Section 1979, 42 U.S.C. Section 1983. The lawsuit claimed that HHC's treatment of Mr. Talevski, in particular, the use of chemical restraints and the persistent transfer attempts, had violated rights that the NRA guaranteed him as a nursing home resident. The district court granted HHC's subsequent motion to dismiss the complaint, reasoning that no plaintiff can enforce provisions of the NRA via Section 1983. The Court of Appeals for the 7th Circuit reversed. It concluded that, under this court's precedent, the relevant NR provisions unambiguously confer individually enforceable rights on nursing home residents, making those rights presumptively enforceable via Section 1983. The Court of Appeals held further that the presumption had not been rebutted here, because nothing in the NA indicated congressional intent to foreclose Section 1983 enforcement of these rights. HHC filed a petition for certiorari, which we granted. For the reasons explained below, we affirm the 7th Circuit's judgment. As relevant here, Section 1983 provides that every person who, under color of any statute, ordinance, regulation, custom, or usage, of any state or territory or the District of Columbia, subjects or causes to be subjected, any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. That is, any person within the jurisdiction of the United States may invoke this cause of action against any other person who, acting under color of state law, has deprived them of any rights, privileges, or immunities secured by the Constitution and laws of the United States. We have been asked before to narrow the scope of this express authorization, i.e., to read laws to mean only civil rights or equal protection laws. We decline to do so, reasoning that a straightforward reading of the plain language of Section 1983 is required. That should have been no surprise. Congress attached no modifiers to the phrase in laws. Since Tabutat, we have crafted a test for determining whether a particular federal law actually secures rights for Section 1983 purposes, but we have not previously doubted that any federal law can do so. HHC attempts to sow renewed doubt about Section 1983's textually unqualified sweep by proffering historical evidence. As background for our evaluation of the particulars of HHC's spending clause-based argument regarding Section 1983's meaning, a fuller picture of the relevant historical context is warranted. Before the Civil War, few direct federal protections for individual rights against state infringements existed. The 13th, 14th, and 15th Amendments worked a sea change in this regard. Still, neither these Civil War amendments nor the landmark Civil Rights Act of 1866 successfully prevented postbellum state actors from continuing to deprive American citizens of federally protected rights. In early 1871, Senate Select Committee produced and distributed a report that ran hundreds of pages and recounted pervasive state-sanctioned lawlessness and violence against the freedmen and their white Republican allies. After reading the report, President Ulysses S. Grant implored Congress to act. It is against this backdrop that the 42D Congress enacted, and President Grant signed, the Civil Rights Act of 1871. The first section of that statute, as reenacted in 1874, created the federal cause of action now codified as Section 1983. The plain language's lack of modifiers reflected the regrettable reality that state instrumentalities could not or would not fully protect federal rights. We have adhered to this understanding of Section 1983's operation. To guarantee the protection of federal rights, the Section 1983 remedy is, in all events, supplementary to any remedy any state might have, and we have consistently refused to read Section 1983's plain language to mean anything other than what it says. We are not persuaded by HHC's argument, which Justice Thomas supports, that Talevski cannot invoke Section 1983 to vindicate the rights the NRA provisions at issue here purport to recognize because Congress seems to have enacted the NRA pursuant to the spending power recognized in Article 1, Section 8 of the Constitution. HHC's argument generally proceeds as follows. Starting with our precedent regarding Congress's spending power, HHC begins by emphasizing our observation that federal legislation premised on that power is much in the nature of a contract, because, in return for federal funds, the states agree to comply with federally imposed conditions. HHC then seizes on the contract analogy to create a syllogism. It reasons that, 1. Any private party suing to enforce an obligation between federal and state governments that a spending clause statute creates is, essentially, a third-party beneficiary, by which HHC means beneficiaries of rights created in any such statute, and, 2. Under common law contract principles extant at the time that Congress enacted Section 1983, third-party beneficiaries were generally barred from suing to enforce contract obligations. Therefore, 3. Plaintiffs like Talevski, as a purported third-party beneficiary of the FNHRA, may not use Section 1983 to do something that third-party beneficiaries of contracts generally could not do in the 1870s. The upshot, for HHC, is that spending clause statutes do not give rise to privately enforceable rights under Section 1983, because contracts were not generally enforceable by third-party beneficiaries at common law. On this basis alone, HHC thus, in effect, urges us to reject decades of precedent, and to rewrite Section 1983's plain text to read laws, unless those laws rest on the spending power. Two well-established principles applied here suffice to reject HHC's invitation to reimagine Congress's handiwork, and our precedent interpreting it. First, our prior Section 1983 cases reference firmly rooted common law principles. We implement Congress's choices rather than remake them. Thus we have reasoned that Congress's failure to displace firmly rooted common law principles generally indicates that it incorporated those established principles into Section 1983. Here, HHC's key common law plank, that third-party beneficiaries could not sue to enforce contractual obligations during the relevant time, is, at a minimum, contestable. A majority of American jurisdictions permitted third-party beneficiaries to sue through at least the early 1870s. The right of a party to maintain a sumpsit on a promise not under seal, made to another for his benefit, is now the prevailing rule in this country. Something more than ambiguous historical evidence is required before we will flatly overrule a number of major decisions of this court, as HHC essentially asks us to do here. Second, because there is no doubt that the cause of action created by Section 1983 is, and was always regarded as, a tort claim, HHC's particular focus on 1870s law governing third-party beneficiary suits in contract is, at the very least, perplexing. If there is a reason that the principles governing those suits should be read to displace the plain scope of Section 1983's species of tort liability, HHC has utterly failed to identify it. We have no doubt that HHC wishes Section 1983 said something else, but that is an appeal better directed to Congress, hewing to Section 1983's text and history. Not to mention our precedent and constitutional role, we reject HHC's request, and reaffirm that laws in Section 1983 means what it says. The NRA can create Section 1983 enforceable rights, but do the two FNHRA provisions at issue in this case actually do so? In that respect, our precedent sets a demanding bar. Statutory provisions must unambiguously confer individual federal rights. For the reasons explained below, we conclude that the bar has been cleared with respect to the presently contested provisions. And while the NRA itself might nevertheless evince Congress's intent to preclude the use of Section 1983 to enforce these particular rights, we hold further that it does not. The NRA provisions at issue in this case, like the rest of the Act, stem from a long-standing national commitment to provide safe and dignified care for the elderly. Since as early as the Social Security Act of 1935, federal law has aimed in myriad ways to promote nursing homes that provide quality services. Yet, concerns about the poor condition of such facilities persisted even after Congress enacted the 1965 Medicare and Medicaid Acts, partly due to widespread non-compliance with existing federal and state laws. Thus, in 1987, Congress passed, and President Ronald Reagan signed, the NASA, affecting a seismic shift in nursing home quality standards. The NRA is largely composed of a litany of statutory requirements that Congress laid out for Medicaid participant states and nursing facilities. Those include requirements relating to residents' rights, two of which Talevski's complaint invoked. The first requires nursing facilities to protect and promote residents' right to be free from any physical or chemical restraints imposed for purposes of discipline or convenience, and not required to treat the resident's medical symptoms, referred to herein as the unnecessary restraint provision. The second appears in a subparagraph concerning, for example, Sections 1396 RC2A-B, referred to herein as the pre-discharge notice provision. As for enforcement, like other aspects of Medicaid, the NFA anticipates cooperative federalism, i.e., federal and state actors working together to carry out the statute's aims. Thus, qualifying state Medicaid plans which are approved by the Secretary of the U.S. Department of Health and Human Services, HHS Secretary, must include provisions that relate to nursing facilities, and must require any nursing facility receiving payments under the plan to satisfy certain NRA mandates. The HHS Secretary must also assure that approved state plans, and the enforcement of plan requirements are, inter alia, adequate to protect the health, safety, welfare, and rights of nursing home residents. The NRA also establishes a detailed administrative scheme for government inspections of nursing facilities. Surveys, in the statute's parlance, must be conducted to detect nursing homes that are falling short of the NRA's minimum standards, and state and federal officials must periodically file certifications, based on these surveys, regarding nursing home compliance. In addition, the statute authorizes government actors to sanction and correct non-compliant facilities, or if appropriate, exclude them from the Medicaid program entirely. Although federal statutes have the potential to create Section 1983 enforceable rights, they do not do so as a matter of course. For spending clause legislation in particular, we have recognized that the typical remedy for state noncompliance with federally imposed conditions is not a private cause of action for noncompliance, but rather action by the federal government to terminate funds to the state. The parties here thus dispute whether this is the atypical case, that is, whether the unnecessary restraint and pre-discharge notice provisions of the NRA unambiguously confer individual rights, making those rights presumptively enforceable under Section 1983. Gonzaga sets forth our established method for ascertaining unambiguous conferral. Courts must employ traditional tools of statutory construction to assess whether Congress has unambiguously conferred individual rights upon a class of beneficiaries to which the plaintiff belongs. Notably, it must be determined that Congress intended to create a federal right for the identified class, not merely that the plaintiffs fall within the general zone of interest that the statute is intended to protect. This paradigm respects Congress's primacy in this arena, and thus vindicates the separation of powers. We have held that the Gonzaga test is satisfied where the provision in question is phrased in terms of the persons benefited and contains rights-creating, individual-centric language with an unmistakable focus on the benefited class. Conversely, we have rejected Section 1983 enforceability where the statutory provision contained no rights-creating language, had an aggregate, not individual, focus, and served primarily to direct the federal government's distribution of public funds. If a statutory provision surmounts this significant hurdle, it secures Section 1983 enforceable rights, consistent with Section 1983's text. And because Section 1983 generally supplies a remedy for the vindication of rights secured by federal statutes, rights so secured are deemed presumptively enforceable under Section 1983. The unnecessary restraint and pre-discharge notice provisions meet this test. To start, we note that both reside in 42 U.S.C. Section 1396 RC, which expressly concerns requirements relating to residents' rights. This framing is indicative of an individual rights-creating focus. Examined further, the text of the unnecessary restraint and pre-discharge notice provisions unambiguously confers rights upon the residents of nursing home facilities. The unnecessary restraint provision requires nursing homes to protect and promote the right to be free from any physical or chemical restraints imposed for purposes of discipline or convenience, and not required to treat the resident's medical symptoms. The provisions' enumerated exceptions further sustain the focus on individual residents. For example, nursing homes may use restraints to ensure the physical safety of the resident or other residents, but only upon the written order of a physician that specifies the duration and circumstances under which the restraints are to be used, absent emergency circumstances specified by the HHS Secretary. The pre-discharge notice provision is more of the same. Nestled in a paragraph concerning transfer and discharge rights, that provision tells nursing facilities that they must not transfer or discharge a resident unless certain preconditions are met, including advance notice of the transfer or discharge to the resident and his or her family. And, again, the statute's caveats remain focused on individual residents. A nursing home may transfer or discharge such an individual if, among other things, the transfer is necessary to meet the resident's welfare, or if the resident's health has improved so much that the facility is no longer necessary, or if the safety or health of other individuals would be endangered. The exceptions to the advance notice requirement. 2. Turn, inter alia, on the resident's health, the resident's urgent medical needs, or the existence of threats to the safety or health of other individuals in the nursing home. To be sure, these two provisions also establish who it is that must respect and honor these statutory rights, namely, the Medicaid participant nursing homes in which these residents reside. But that is not a material diversion from the necessary focus on the nursing home residents, contrary to HHC's representations. Indeed, it would be strange to hold that a statutory provision fails to secure rights simply because it considers, alongside the rights bearers, the actors that might threaten those rights, and we have never so held. The unnecessary restraint and pre-discharge notice provisions thus stand in stark contrast to the statutory provisions that failed Gonzaga's test in Gonzaga itself. Those provisions lacked rights-creating language, primarily directed the federal government's distribution of public funds, and had an aggregate, not individual focus. The opposite is true here. The unnecessary restraint and pre-discharge notice provisions use clear rights-creating language, speak in terms of the persons benefited, and have an unmistakable focus on the benefited class. Thus they satisfy Gonzaga's stringent standard, and the rights they recognize are presumptively enforceable under Section 1983. Even if a statutory provision unambiguously secures rights, a defendant may defeat the presumption by demonstrating that Congress did not intend that Section 1983 be available to enforce those rights. For evidence of such intent, we have looked to the statute creating the right. A statute could, of course, expressly forbid Section 1983's use. Absent such a sign, a defendant must show that Congress issued the same command implicitly, by creating a comprehensive enforcement scheme that is incompatible with individual enforcement under Section 1983. Only the latter path is at issue here. Our precedent outlines what HHC must show to traverse the implicit preclusion path. The crucial consideration is whether Congress intended a statute's remedial scheme to be the exclusive avenue through which a plaintiff may assert his claims. Our precedents make clear that the sine qua non of a finding that Congress implicitly intended to preclude a private right of action under Section 1983 is incompatibility between enforcement under Section 1983 and the enforcement scheme that Congress has enacted. We have used many terms and concepts to describe the necessary discordance between Section 1983 and a rights-conferring statute's remedial scheme, incompatible, inconsistent, and thwart our examples. In all events, the question is whether the design of the enforcement scheme in the rights-conferring statute is inconsistent with enforcement under Section 1983, such that a court must infer that Congress did not intend to make available the Section 1983 remedy for these newly created rights. Put another way, the inquiry boils down to what Congress intended, as divined from text and context. The application of the traditional tools of statutory construction to a statute's remedial scheme may reveal no incompatibility between the enforcement scheme that Congress crafted in the rights-conferring statute and enforcement under Section 1983, or it may uncover sufficient incompatibility to make manifest Congress's intent to preclude Section 1983 actions. We discern no incompatibility between the FNHRA's remedial scheme and Section 1983 enforcement of the rights that the unnecessary restraint and pre-discharge notice provisions unambiguously secure. As explained in Part 3a, supra, the FNHRA details administrative processes concerning inspection of covered nursing facilities and accountability for non-compliant facilities. But the statute lacks any indicia of congressional intent to preclude Section 1983 enforcement, such as an express private judicial right of action or any other provision that might signify that intent. Nor has HHC otherwise demonstrated that enforcement via Section 1983 would thwart the operation of the administrative remedial scheme in any respect. HHC's argument? that we need look no further than the detail of the NRA's enforcement mechanisms to find conclusive evidence of implicit preclusion is unpersuasive. Implicit preclusion is shown by a comprehensive enforcement scheme that is incompatible with individual enforcement under Section 1983. HHC's single-minded focus on comprehensiveness mistakes the shadow for the substance, and it disregards the import of these NRA provisions' unambiguous conferral of rights. The attendant presumption is that Section 1983 can play its textually prescribed role as a vehicle for enforcing those rights, even alongside a detailed enforcement regime that also protects those interests, so long as Section 1983 enforcement is not incompatible with Congress's handiwork. To be clear, a defendant can discharge its burden of showing that the presumption is rebutted by pointing to a comprehensive scheme. But when a particular comprehensive remedial scheme discharges the defendant's burden, it does so because the application of ordinary interpretive tools reveals incompatibility, i.e., it demonstrates that Congress intended that statute's remedial scheme to be the exclusive avenue through which a plaintiff may assert his claims. Nothing in the NA indicates the incompatibility evinced in our three prior cases finding implicit preclusion. Rancho Palos Verdes, Smith, and C. claimers concerned statutes with self-contained enforcement schemes that included statute-specific rights of action. Each such statute required plaintiffs to comply with particular procedures, and/or to exhaust particular administrative remedies under the statute's enforcement scheme before suing under its dedicated right of action. And each statute-specific right of action offered fewer benefits than those available under Section 1983. Thus, in all three cases, Section 1983's operation would have thwarted Congress's scheme coming and going. It would have circumvented the statute's pre-suit procedures, and would have also given plaintiffs access to tangible benefits as remedies that were unavailable under the statutes. Those comprehensive enforcement schemes were incompatible with individual enforcement under Section 1983. HHC has identified no equivalent sign in the FNHRA, nor has Justice Alito. In focusing on what the NRA contains, they ignore what it lacks: a private judicial right of action, a private federal administrative remedy, or any careful congressional tailoring that Section 1983 actions would distort. HHC seems to think it enough to show that Congress was not slipshod in crafting the remedial scheme. But in a world where the NRA's remedial scheme could complement, not supplant, Section 1983, HHC must demonstrate more than that. One last rebuttal argument warrants addressing. The United States says that, because private entities owned most nursing homes when the NRA was enacted in 1987, as they do now, the NRA is a rare bird for implicit preclusion purposes. In the United States' view, because Congress knew that most nursing homes could not be subject to suit under Section 1983 anyway, the NRA's remedial scheme necessarily reflects Congress's judgment that these administrative enforcement mechanisms appropriately protect the rights the statute confers. This argument is unavailing. The implicit preclusion inquiry looks to the statute creating the right and any comprehensive enforcement scheme Congress has created in the statute that is incompatible with individual enforcement under Section 1983. It does not invite speculation about ostensible marketplace realities that appear nowhere in the statute's text or relevant context. The relevant NRA provisions speak in neutral terms that do not distinguish between private and public nursing homes. And, regardless, the question remains whether something in the NA has foreclosed Section 1983's general availability as a remedy for the vindication of rights secured by federal statutes. We see no such sign, much less a license for us to construct and impute congressional intent that the NRA does not embody. The difficulty for HHC in the United States is that implicit preclusion, in this context, requires something in the statute that shows that permitting Section 1983 to operate would thwart Congress' intent in crafting the FNHRA. We see nothing in the NRA that even hints at Congress's intent in this regard. If anything, the language of the Act confirms otherwise, for it plainly states that the remedies provided under its enforcement process subsection are in addition to those otherwise available under state or federal law, and shall not be construed as limiting such other remedies. We will not rewrite Section 1396 RH8 in lieu of rewriting Section 1983. At oral argument, HHC's counsel remarked that the right question is what rights are secured by law within the meaning of Section 1983. That is an accurate statement of the key issue in this case. Section 1983 itself provides the answer. By its terms, Section 1983 is available to enforce every right that Congress validly and unambiguously creates. We will not impose a categorical font of power condition that the Reconstruction Congress did not. And here, the test that our precedents establish leads inexorably to the conclusion that the NRA secures the particular rights that Talevski invokes, without otherwise signaling that enforcement of those rights via Section 1983 is precluded as incompatible with the NFA's remedial scheme. Accordingly, we affirm the judgment of the Court of Appeals. It is so ordered. Justice Gorsuch, concurring, Section 1983 permits individuals to sue to vindicate their rights, secured by law. I agree with the court's disposition of the two questions we took this case to decide, and in arriving there largely tracked Justice Barrett's reasoning. First, the Federal Nursing Home Reform Act qualifies as a law for purposes of Section 1983. Second, the text of the Act's operative provisions refers to individual rights. But, to my mind, there are other issues lurking here that petitioners failed to develop fully. Whether legal rights provided for in spending power legislation like the Act are secured as against states in particular, and whether they may be so secured consistent with the Constitution's anti-commandeering principle. As I see it, those are questions for another day. Justice Barrett, with whom the Chief Justice joins, concurring. Today's opinion makes three important points. First, Maine v. Tabutat remains good law. Second, Gonzaga University v. Doe sets the standard for determining when a spending clause statute confers individual rights, and the Federal Nursing Home Reform Act (FNHRA) satisfies it. Third, courts must carefully consider whether individual rights established by a spending clause statute are enforceable through Section 1983. In the NMS case, they are. As to the first point, Section 1983 provides a cause of action against every person who, under color of state law, violates any rights, privileges, or immunities secured by the Constitution and laws. In Tabutat, we held that the plain language of the statute was not limited to some subset of laws. Rather, the term laws encompasses all federal laws, including those passed pursuant to Congress's spending clause authority. Like the court, I would not abandon that holding based on petitioner's novel contract law theory. Second, our decision in Gonzaga establishes the standard for analyzing whether spending clause statutes give rise to individual rights. Under Gonzaga, courts must ask whether text and structure indicate that the statute unambiguously confers federal rights. Relevant considerations include whether the statute is phrased in terms of the persons benefited, whether it uses explicit rights-creating terms, and whether it has an individual, rather than an aggregate, focus. This bar is high, and although the NRA clears it, many federal statutes will not. As the court explains, Section 1983 actions are the exception, not the rule, for violations of spending clause statutes. This is because the typical remedy for state noncompliance with federally imposed conditions is not a private cause of action for noncompliance, but rather action by the federal government to terminate funds to the state. Indeed, since Pennhurst, we have interpreted only two spending clause statutes to be enforceable through Section 1983. The third point is that even when a statute unambiguously confers rights, Congress can supplant any remedy that otherwise would be available under Section 1983. At this step of the analysis, courts should apply ordinary interpretive tools to determine whether the statute allows access to Section 1983. In some cases, the text may expressly forbid Section 1983 actions. In others, context may point to the same result. It is especially telling, for example, if the statute creates a comprehensive enforcement scheme that is incompatible with individual enforcement under Section 1983. As the court notes, the presence of an express private judicial right of action typically demonstrates that a Section 1983 suit is not also available. When the statutory cause of action restricts available remedies or imposes procedural hurdles to obtaining relief, the inference is even stronger. But an actual clash, one private judicial remedy against another, more expansive remedy, is not required to find that a statute forecloses recourse to Section 1983. Our cases have looked to a wide range of contextual clues, like enforcement provisions that confer authority to sue, on government officials, and any administrative remedies that the statute offers. We have noted the relevance of a centralized review mechanism that would be undermined by piecemeal litigation, and we have regularly taken account of the overall comprehensiveness of the statute's enforcement scheme. The more comprehensive the scheme, the less likely that it leaves the door open for Section 1983 suits. None of these features is necessarily determinative, but each is part of the larger picture that courts must assess. Courts must tread carefully before concluding that spending clause statutes may be enforced through Section 1983. In this case, however, the Seventh Circuit correctly allowed Talevski's Section 1983 suit to proceed. I therefore join the court's opinion in full. Justice Thomas, dissenting. I agree with Justice Alito that the Federal Nursing Home Reform Act, FNHRA, cannot be enforced through Section 1983, under the standards set forth in Gonzaga University v. Doe. I write separately to highlight another and more fundamental reason why NRA cannot be enforced under Section 1983. Section 1983 provides a cause of action to redress only the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. But legislation enacted pursuant to Congress's spending power, like NRA, does not secure rights by law. For nearly all of our nation's history, it was understood that there is a fundamental difference between the exercise of Congress's sovereign legislative powers, on the one hand, and the exercise of its power to spend money and to attach conditions to the receipt of that money, on the other. Only the former sort of legislation, which imposes obligations on regulated parties with the force of law, directly secures by law the rights corresponding to those obligations. By contrast, an exercise of Congress's spending power, whether it comes from the so-called spending clause or elsewhere in the Constitution, is no more than a disposition of funds. As such, a conditional exercise of the spending power is nothing more than a contractual offer. Any rights that may flow from that offer are secured only by the offeree's acceptance and implementation, not federal law itself. Since Maine v. Tibutat, however, this court has ignored that fundamental distinction, permitting third parties who benefit from spending conditions to enforce them in Section 1983 suits against state actors. In doing so, it has created a constitutional quandary. If spending conditions that benefit third parties are laws and secure rights in the same manner as ordinary lawmaking under Congress's sovereign legislative powers, then such conditions would contradict the bedrock constitutional prohibition against federal commandeering of the states. We escape this quandary only by recognizing spending conditions, not as rights-securing laws, but as the terms of possible contracts that secure rights only by virtue of an offeree's acceptance, the very conclusion compelled by the traditional understanding of the spending power. The choice between these alternatives is stark and unavoidable. Either spending conditions in statutes like NRA are not laws that secure rights cognizable under Section 1983, or they are unconstitutional direct regulations of states. The court must, at some point, revisit its understanding of the spending power and its relation to Section 1983. This case arises from a Section 1983 suit to enforce FNHRA's spending conditions against a county-owned nursing home that receives federal funding. Enacted under Congress's spending power, NRA conditions the receipt of federal Medicaid funding by states and nursing facilities on compliance with a broad range of requirements. These conditions largely consist of requirements that funding recipients protect certain rights of nursing home residents. In a subsection entitled Requirements Relating to Residents' Rights, the Act requires recipients to protect and promote the rights of each resident, including the right to choose a personal attending physician and make informed medical decisions, the right to be free from physical or mental abuse, corporal punishment, involuntary seclusion, and any medically unnecessary physical or chemical restraints, and the rights to privacy and confidentiality. The Act further provides that funding recipients must permit each resident to remain in the facility and must not transfer or discharge the resident without cause. Recipients must also adopt procedures for residents to assert these rights, and to otherwise voice grievances with respect to their treatment or care. The Act also imposes many requirements directly and uniquely upon participating states, including in a subsection entitled State Requirements Relating to Nursing Facility Requirements. For instance, states must establish procedures for residents to challenge transfer and discharge decisions, and an appeals process for other determinations. States are also required to certify non-state-run facilities' compliance with the Act's provisions by conducting annual surveys using protocols developed by the Secretary of Health and Human Services. If a state finds that a facility is not providing adequate care, it must conduct an extended survey. The Act also requires states to investigate resident complaints and perform on-site monitoring at previously non-compliant or potentially non-compliant facilities. And, if it finds a violation that jeopardizes the health or safety of a facility's residents, the state shall take immediate action to remove the jeopardy and correct the deficiencies. FNHRA's scheme is illustrative of many modern federal spending programs, which often impose obligations directly on states as a condition of funding. For example, as a condition on highway funding, the Clean Air Act requires states to draft state implementation plans if their metropolitan areas fail to satisfy national ambient air quality standards. Among other requirements, these plans must include emission limitations, compliance timetables, source monitoring, permitting systems, enforcement programs, and public participation. Other examples, spanning virtually every domain of national and state policy, abound. The ubiquity of such spending conditions, combined with the federal government's overwhelming financial heft, has made spending clause legislation an extraordinarily potent instrument of federal control. Congress and federal agencies regularly use conditions to direct state and local governments in their regulatory and spending policies. As a result, the priorities and programs of state and local governments have increasingly come to reflect federal decisions, to the point that the states have virtually become disaggregated sites of national governance, not separate sovereigns. Given the profound consequences of spending conditions for the nation's governance, and the fundamental shift that they have wrought in our federalist system, a sound understanding of their constitutional basis and permissible legal effects is essential. This case presents one aspect of that question: whether spending conditions that impose obligations on states for the benefit of third parties may be enforced under Section 1983. That statute provides a cause of action against any person who, under color of state law, deprives the plaintiff of any rights, privileges, or immunities secured by the Constitution and laws. Accordingly, for the violation of a federal statutory provision to give rise to a cognizable Section 1983 claim, the provision must confer rights, privileges, or immunities that are secured by law. This court's cases make clear that a right is secured by law in the relevant sense if, and only if, federal law imposes a binding obligation on the defendant to respect a corresponding substantive right that belongs to the plaintiff. It is obvious, however, that conditional spending legislation does not function, and, in particular, does not secure rights like laws enacted under Congress enumerated legislative powers, such as the Commerce Clause. The latter, which I will refer to as sovereign legislative or regulatory powers, include powers to directly impose obligations, duties, prohibitions, and the like on individuals and entities beyond the federal government, and hence to secure corresponding rights in the persons and entities to which such obligations are owed. Laws that Congress enacts pursuant to its regulatory powers are binding on the regulated parties, and preempt contrary state law of their own force. Whatever rights such laws secure, those rights are secured by the laws themselves. By contrast, legislation that conditions a state's receipt of federal funds on compliance with certain requirements imposes no obligations and secures no rights of its own force. The stated conditions simply have no effect and do not arguably secure any rights, by law or otherwise, unless and until they are freely accepted by the state. Not only that, the executive branch can prevent the conditions from taking effect by rejecting a state's application to participate in the spending program, and it can terminate their effect by cutting off a state's participation for non-compliance with the conditions. In addition, states can opt out of spending programs, completely nullifying whatever force the spending conditions once had. This alone suggests that spending conditions do not operate with the force of federal law, as Congress' legislative powers cannot be avoided by simply opting out. Indeed, spending conditions like those in NRA do not function as laws enacted under Congress' regulatory powers, and, if they did, they would unconstitutionally commandeer the states to administer federal programs ranging from welfare, to healthcare, to air quality, and much more. Such conditions are thus constitutional, if at all, only if understood as setting forth the terms of a federal-state contract, rather than as binding federal law imposing legally enforceable obligations of its own force. In holding that NRA secures rights by federal law, the majority ignores the contractual understanding of spending conditions and, by doing so, calls their very constitutionality into question. As noted earlier, a defining characteristic of modern spending legislation is the imposition of obligations on states that accept federal funds. Understanding a state's breach of such obligations as akin to violating rights secured by federal law is incompatible with this court's anti-commandeering doctrine. Under this bedrock constitutional principle, Congress generally cannot directly regulate the states or require them to implement federal programs. When the original states declared their independence, they claimed the powers inherent in sovereignty. Later, in ratifying the Constitution, the people of the original states granted carefully enumerated legislative powers to the new federal Congress, while preserving the state's pre-existing legislative power. Conspicuously absent from Congress' enumerated powers was the power to issue direct orders to the governments of the states. Thus, as this court has made clear, the Constitution confers upon Congress the power to regulate individuals, not states. As a corollary, Congress may not conscript state governments as its agents, nor can it require the states to govern according to its instructions. And, whatever the outer limits of state sovereignty may be, one thing is clear: the federal government may not compel the states to enact or administer a federal regulatory program. Yet that is precisely what many spending conditions require the state to do. Spending conditions like FNHRAs are nothing more than commands to states, qua-states, to administer federal benefits programs on terms dictated by Congress. Such conditions cannot be treated as having the force of federal law imposing direct obligations on the states and securing correlative rights of private parties without violating the anti-commandeering doctrine. It is no answer that the states consent to direct regulation by agreeing to the spending conditions in return for federal dollars. As the court held in New York, where Congress exceeds its authority relative to the states, the departure from the constitutional plan cannot be ratified by the consent of state officials. Because the people have surrendered only limited and enumerated powers to the federal government, the states and Congress cannot jointly circumvent the ratification and amendment process by agreeing to the enlargement of the powers of Congress beyond those enumerated in the Constitution. The federal government cannot buy, or rent, the state's power to implement a federal program and then regard the conditions that the states are implementing themselves as having the force of federal law. Of course, it is ultimately the state's consent that gives effect to conditions in spending legislation, but it does so in an entirely different manner from an illicit expansion of Congress' regulatory powers. Rather, as the court observed in Pennhurst State School and Hospital v. Halderman, legislation enacted pursuant to the spending power is much in the nature of a contract. A federal statute imposing conditions upon the receipt of federal funding does not enact those conditions with the obligation of law. It merely proposes them as the terms of a contractual promise. Such spending provisions merely stipulate what the government expects from recipients if it is to pay them, or, later, not withhold further payment and demand its money back. Thus, even when fully recited in statutes, federal conditions do not come with legal obligation. Further, and as already noted, the conditions in spending legislation only come into force upon the acceptance of another party. Such conditions are thus obligatory only by virtue of such agreement and not by force of law. To be sure, it is a statute that prescribes the funding condition and requires denial of federal assistance if the funding condition is not agreed to. But only the agreement, and not the statute, makes the terms obligatory on the fund's recipient and thus secures the contemplated third-party rights. Accordingly, such third-party rights are secured, if at all, not by any law, but only by the contract between the recipient and the United States. This contractual understanding of conditional spending legislation is much more than a mere analogy. It is the only possible explanation for why such legislation is not an unconstitutional direct regulation of the states. To deny or downplay this principle is to seek to have it both ways. Much spending legislation conditions states' receipt of federal funds on their undertaking obligations with respect to third parties. For such legislation to survive a federalism challenge, it must not directly impose obligations on the states with the force of federal law. But, for those conditions to be enforceable under Section 1983, they must secure third-party rights by directly imposing correlative obligations on the states with the force of federal law. Both of these things cannot be true. This contractual understanding of spending conditions is also a necessary consequence of the limited nature of Congress' spending power, as consistently understood for nearly 2 centuries of our nation's history. Indeed, this is one point on which the framers all seem to have agreed. Despite heated debates over the source and scope of Congress' power to spend, all understood that this power did not carry with it any independent regulatory authority. That agreement persisted throughout the 19th century. And, in the 20th, it was a critical underpinning of this court's precedents upholding expansive uses of the spending power as consistent with Congress' limited legislative powers and our federalist system of government. At the outset, while Congress undoubtedly possesses the power to direct the expenditure of federal funds, it is important to note that the Constitution contains no spending clause. From the beginning, some have located the spending power in the General Welfare Clause, and that view has generally been accepted by this court's modern doctrine. Yet there are serious problems with that view. The General Welfare Clause is simply part of the Taxing Clause, which reads in relevant part, "The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States." By its terms, the only authority vested by this text is a power to lay and collect taxes, duties, imposts, and excises. This power is then qualified by the debts and general welfare clauses, which limit the objects for which Congress can exercise that power. The General Welfare Clause is thus most naturally read as a qualification on the substantive taxing power. Consider also that the General Welfare Clause references not only the general welfare but also the common defense. If the clause were construed as an affirmative grant of power to spend for the common defense, it would make redundant Congress powers to raise and support armies and to provide and maintain a navy, also found in Article I. Thus, if the reference to common defense spending simply alludes to power conferred elsewhere, then it seems illogical to consider the terms general welfare as the source of a freestanding power to spend for whatever purposes. The Taxing Clause is also a strange candidate for the source of a general congressional spending power, because it fails to provide any authority at all to spend money acquired otherwise than by taxation. Yet the federal treasury receives money from many other sources, including penalties, fines, user fees, leases, surplus property sales, gifts, bequests, and returns on investments. And those sums are a pittance in comparison to those raised under Congress' borrowing clause power, which has always been one of the major sources of federal funds. Unless federal spending on credit and from revenues not derived from taxes, duties, imposts, and excises is unconstitutional, the General Welfare Clause cannot be the source of Congress' spending power. The clause certainly is not an independent grant of regulatory power to legislate for the general welfare, as the history of the Constitution's framing and ratification makes clear. The Philadelphia Convention initially adopted a resolution that Congress be authorized to legislate in all cases for the general interests of the Union, and also in those to which the states are separately incompetent, or in which the harmony of the United States may be interrupted by the exercise of individual legislation. But the Convention later abandoned this vesting of a broad power to legislate for the general welfare in favor of the enumeration of specific federal legislative powers, and the creation of a taxing power limited by the General Welfare Clause. Consistent with its text, Federalist advocates of the Constitution defended the General Welfare Clause to the ratifying public as nothing more than a limitation on the taxing power. Their basic message was that the language in question was not a grant at all, rather it was a restriction on federal authority. As Governor Randolph emphatically declared, "Is this an independent, separate, substantive power to provide for the general welfare of the United States? No, sir." Federalists went out of their way to specifically disclaim that the General Welfare Clause would vest any independent regulatory power. For example, James Madison expressly rejected anti-federalist attempts to portray the General Welfare Clause as granting an unlimited commission to exercise every power which may be alleged to be necessary for the common defense or general welfare. Similarly, in rebutting Patrick Henry's warning that the clause would vest a regulatory power, Governor Randolph observed, "You must violate every rule of construction and common sense, if you sever it from the power of raising money, and annex it to anything else, in order to make it that formidable power which it is represented to be." Again and again, leading Federalists represented the General Welfare Clause simply as qualifying the fiscal power. It was generally understood by the Constitution's ratifiers that the General Welfare Clause did not confer power to regulate. Such regulatory powers were conferred only by specific enumerations such as the Commerce Clause. Thus, even if one implausibly regards the General Welfare Clause as a spending clause, it is unambiguous that the clause confers no independent regulatory power. Importantly, the same holds for every other plausible textual anchor for Congress' general spending power. First, the necessary and proper clause is a natural candidate for the spending power, because spending funds may be necessary and proper for carrying into execution the federal government's enumerated powers. But because the clause authorizes only those spending measures that are necessary and proper for carrying into execution other enumerated federal powers, Congress can spend only if the appropriation is tied to the execution of one of the federal government's granted powers. The clause thus does not provide a standalone grant of spending authority, and certainly not an authority to spend for a non-specific general welfare of the United States. A second plausible source of the spending power is the Property Clause, which provides that Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. The term other property may comprehend personal property no less than real, and personal property includes money as well as financial assets of all kinds. But the power to dispose of funds does not carry with it any regulatory power. The Property Clause only authorizes the control and disposition of federal property, and does not disturb the allocation of governance authority otherwise accomplished under the principle of enumerated powers. Thus, when disposing of federal property under the Property Clause, Congress has no more competence to make law than any private donor or testator has. In the early decades after ratification, both the source and the scope of the spending power were hotly contested, usually in debates over internal improvements such as roads and canals. One side, represented by Madison, maintained that federal spending must be strictly in aid of the federal government's specifically enumerated powers. For instance, expenditures to construct a road would be justified only if the road could be constructed under the Post Roads Clause, or some other enumerated power. As this side of the debate also took a narrow view of the enumerated powers, it generally argued that the federal government could not fund internal improvements without a constitutional amendment. The other camp, associated with the nationalist views of Hamilton and Joseph Story, understood the General Welfare Clause to include a very broad spending authority, which could be applied to purposes not specifically enumerated by the Constitution. Even this camp, however, understood that the General Welfare Clause does not include a power to regulate. Hamilton, for example, made clear that the spending power did not imply a power to do whatever else should appear to Congress conducive to the general welfare. As he further elaborated, a power to appropriate money does not carry a power to do any other thing, not authorized in the Constitution, either expressly or by fair implication. Instead, any regulatory authority had to be tethered to some independent regulatory power. Thus, under this view, Congress could spend money on roads and canals unconnected with the enumerated powers, but it would have to depend on the states for any regulatory legislation needed to complete and preserve the improvements. This understanding that the spending power itself extended only to the application of money, led Hamilton to favor a constitutional amendment empowering Congress to open canals. After all, opening canals involved much more than spending money. It involved acquiring rights-of-way and constructing and operating the improvements. Thus, it was precisely the insufficiency of the spending power to override state law obstacles to achieving the targeted end that made Hamilton conclude that a constitutional amendment for canals was necessary. Federal funding alone could not override incompatible or adverse state policies. As this example demonstrates, even those who held the broadest conception of the spending power recognized that it was only a power to spend, not a power to impose binding requirements with the force of federal law. The limited nature of the spending power was also a rare point of agreement in Hamilton and Jefferson's bitter quarrel over the constitutionality of a national bank. Reflecting the ratification-era understanding of the General Welfare Clause, Jefferson observed that the laying of taxes is the power and the general welfare the purpose for which the power is to be exercised. If the General Welfare Clause went beyond describing the purpose of the taxing clause, and represented a distinct and independent power to do any act Congress may please, which might be for the good of the Union, it would render all the preceding and subsequent enumerations of power completely useless. In response, Hamilton justified the bank based on Congress-enumerated powers, such as the commerce and taxing clauses. He discussed the General Welfare Clause only as a limitation. It is true that Congress cannot, without breach of trust, lay taxes for any other purpose than the general welfare. In his view, the spending power was emphatically limited to the application of money. Jefferson and Hamilton could agree that it was no independent font of legislative power. In sum, the framers and ratifiers understood the taxing and general welfare clause as granting only a power to tax. What our modern cases refer to as the spending clause, in fact, the general welfare clause, was understood by the framers and the ratifying public as granting no regulatory authority. One thing that the opposing men and factions of the founding generation agreed upon was that the federal government's power to spend was just that, a power to spend, involving no regulatory authority. Instead, the power to bind with the force of law must come from Congress-enumerated legislative powers rather than its spending power. Though the scope and source of the spending power continued to be vigorously contested into the 19th century, the fundamental understanding that federal spending measures could not bind with the force of law remained common ground. For example, in his last official act, President Madison vetoed an internal improvements bill in part because the train of powers incident to constructing and maintaining such improvements were beyond Congress-enumerated powers. The General Welfare Clause could not provide the needed regulatory authority, as such an interpretation would have the effect of giving to Congress a general power of legislation, thus rendering the Constitution's special and careful enumeration of powers nugatory and improper. That the bill required state consent was likewise insufficient because, if the power be not possessed by Congress, the assent of the states cannot confer the power. Upon assuming office, President James Monroe sent a message to Congress agreeing with Madison's views. The message was then referred to a special committee in the House of Representatives, led by Congressman Henry Tucker. The Tucker Committee produced an exhaustive report on internal improvements, which disagreed with nearly every aspect of Madison and Monroe's position. Significantly, however, the committee agreed that the General Welfare Clause did not vest the power needed to make internal improvements, relying instead on the Constitution's specific enumerations such as the Post-Rhodes Clause. The Tucker Committee also agreed with President Monroe that the spending power did not extend the specified or incidental powers of the government, or allow Congress to exercise any jurisdictional, i.e., regulatory rights over improvements. Thus, if the power to make a road or dig a canal is not given by one of Congress' enumerated regulatory powers, the power of appropriating money cannot confer it. In his second term, President Monroe set forth the fullest exposition of the understanding that the spending power involved no regulatory authority. In 1822, Congress passed a bill to establish a system of internal improvements, asserting the power to establish turnpikes with gates and tolls, and to enforce the collection of tolls by federal penalties. President Monroe then vetoed the measure, judging that Congress' spending authority did not extend to such a complete right of jurisdiction and sovereignty for all the purposes of internal improvement, and not merely the right of applying money under the power vested in Congress to make appropriations. Because Monroe understood that Congress does not possess this power, and the states individually cannot grant it, he agreed with Madison and Hamilton that the power can be granted only by an amendment to the Constitution. To explain his veto, President Monroe sent Congress an extensive report entitled Views of the President of the United States on the Subject of Internal Improvements. In this report, perhaps the most elaborate constitutional discussion ever sent to the Capitol from the White House, Monroe synthesized the understanding of the spending power from the founding of the Republic. And, in doing so, he largely settled the contours of that understanding for over a century. In the centerpiece of the views, Monroe explained that the spending power carries no incidental power to regulate individuals or states. Echoing Hamilton, Monroe understood the spending power to consist of a right to appropriate the public money, and nothing more. It carries with it no incidental power, nor does it draw after it any consequences of that kind. Monroe proceeded to carefully distinguish the spending power from Congress' authority to impose obligations and duties, the use or applications of the money after it is raised is a power altogether of a different character from Congress' enumerated regulatory powers such as the taxing power. It imposes no burden on the people, nor can it act on them in a sense to take power from the states. Applying this understanding of the spending power to the question of internal improvements, Monroe explained that Congress could only appropriate the money necessary to make them, where none of Congress' enumerated regulatory powers was applicable. Monroe concluded, for every act requiring legislative sanction or support, the state authority must be relied on. Thus, Congress could not itself pass laws providing for the condemnation of the land, the establishment of turnpikes and tolls, and the protection of the work when finished. Monroe's summation of the federal spending power, reflecting that it does not carry with it any regulatory power, was accepted throughout the 19th century by friends and foes of federal power alike. In his 1825 inaugural address, President John Quincy Adams explained that Monroe's views had conciliated the sentiments and approximated the opinions of enlightened minds upon the question of constitutional power. 5 years later, President Andrew Jackson vetoed the Maysville Road Bill of 1830 for the same reasons Monroe had vetoed the Cumberland Road Bill of 1822. Congress lacks the right to exercise as much jurisdiction as is necessary to preserve the works and to raise funds by the collection of tolls to keep them in repair, and without such power nothing extensively useful can be effected. Justice Joseph Story's commentaries on the Constitution also recognized that the spending power did not carry with it any auxiliary power to bind individuals or states. Citing Monroe's views liberally, Story agreed that Congress could not enact a system of internal improvements under the General Welfare Clause. Although he located the spending power in that clause, Story understood that the power was confined to mere appropriations of money, and that, as a result, the federal government could not regulate internal improvements except pursuant to its legislative enumerated powers. Although disagreement on whether Congress could spend for purposes beyond the enumerated powers persisted through the antebellum and Reconstruction eras, the understanding that the spending power did not imply regulatory power persisted. Because Congress was acting solely under its power to spend, it relied on the state's acceptance of terms and upon the state's legislative powers to carry out federal spending programs. Given this consensus, it is not surprising that the first federal grant-in-aid spending programs were contractual in nature. The Morrill Act of 1862, perhaps the first such program, extended an offer to the states to accept donations of federal lands on the condition that the state use the land to establish a college. States had 2 years to accept the federal terms in the form of an act by the state's legislature. Significantly, the only consequence for a state's breach of the use condition was contractual in nature. The grant to such state shall cease, and said state shall be bound to pay the United States the amount received of any lands previously sold. The Second Morrill Act, enacted in 1890, followed the same framework, donating money for the endowment of agricultural and mechanical arts colleges, subject to the condition that black students not be excluded. Like the first Morrill Act, the only consequence for non-compliance was that future appropriations under the act would cease until the state brought itself into compliance. In the early 20th century, the adoption of the 16th Amendment and the national income tax vastly expanded the revenue available to the federal government. But the increasingly ambitious spending programs that followed did not break the contractual pattern established by the Morrill Acts. Thus, early 20th century highway grants took the form of an offer to enter a contract, with the consequence of non-compliance being the cutoff of federal funds. Even in the New Deal era, advocates of far-reaching spending programs continued to understand the spending power as a mere power of appropriation. Professor Corwin recognized that the states must be depended upon to exercise the legislative power needed to implement such programs. Thus, federal highway construction relied on the state power of eminent domain, as well as on state power to police and protect highways during and after their construction. Similarly, national protection of forests depended on the power of the states to regulate the conduct of persons entering forests, and the provision of maternity benefits depended on the power of the cooperating states to compel birth registration, the licensing of midwives, etc. Thus, more than 100 years after Monroe's views, it was still well understood that the federal government's spending power needed to work with the wider coercive powers of the states to accomplish its ends. And, a state's acceptance of federal funds in return for exercising its own powers did not expand the federal government's legislative powers. In sum, from the framing of the Constitution to well into the 20th century, it was virtually undisputed that Congress' spending power was nothing more than a power to spend. It included no regulatory authority to bind parties, to secure rights or impose duties with the force of federal law, and no authority to directly regulate the states even with their consent. When cases concerning expansive federal spending programs first began to reach this court, they vividly illustrated both the enduring understanding of the spending power as a non-regulatory power and the contractual understanding of spending conditions. The federal government defended major spending programs on the basis of that understanding, and the programs survived this court's review only because of those traditional premises. In Massachusetts v. Mellon, the court rejected as non-justiciable Massachusetts' claim that the Maternity Act of 1921 was an attempt to legislate outside the powers granted to Congress by the Constitution and within the field of local powers exclusively reserved to the states. The court first stated that it probably would be sufficient to point out that the powers of the state are not invaded, since the statute imposes no obligation but simply extends an option which the state is free to accept or reject. In other words, the state could not be injured because the act was not a direct legal regulation. Rather, it was a mere offer to bargain. It imposed no burden upon the states, and did not require them to do or to yield anything of its own force. The state could not seek judicial redress, because the contractual nature of the Act's provisions meant that states could vindicate their own rights by the simple expedient of not yielding. Cases involving New Deal spending programs teach the same lesson. For example, United States v. Butler concerned the constitutionality of the Agricultural Adjustment Act, which offered subsidies to farmers not to sell crops. The government defended the act on the ground that it did not regulate any private or state party. Instead, any commands or restrictions in the act were imposed only upon the use by federal administrative officials of the money granted. In line with the traditional distinction between mere spending and regulatory commands, the government urged that Congress had not gone beyond its power of authorizing an expenditure precisely because it had not sought to force or command citizens to receive the money offered and to perform the conditions upon which the funds are to be dispersed. The government expressly relied on the contractual nature of the Act's conditions, as distinct from any exercise of sovereign regulation. It would be most unusual to suppose that a contract of this nature, entered into freely by both parties, is an exercise of sovereign regulation and control over one of the parties, or over the subject matter with which the contract deals. The rights of the United States under the contracts are no greater than would be the rights of a private citizen under similar contracts, and enforcement must be by ordinary judicial process according to the law of the forum. The contracts are not derogatory of any sovereign rights of the states. They are carried out pursuant to and under the protection of the laws of the states. The purpose and effect of the contracts so entered into are simply to accomplish the spending of the money on the conditions imposed by Congress, and in authorizing execution of such contracts, Congress was not exerting a power outside of the field of appropriation. The government also disclaimed that the act would have preemptive effect, because it went no further than offering benefits to those who comply with certain conditions. States remained as free after the passage of this act as before to pass laws, rendering it impossible for any of their inhabitants to comply with such conditions. Thus, to avoid a 10th Amendment problem, the government relied on the traditional distinction between the federal government's power to spend and its power to regulate. The distinction between an application of the federal lawmaking power to enforce compliance with the desire of Congress, and the use of the spending power to offer benefits which might persuade people to that end, was recognized in this manner by the first Congresses. When the United States goes no further than extending benefits to citizens who arrange their affairs in a manner thought beneficial by Congress, there is no direct exercise of federal power on those affairs, and they remain subject to the unhampered control of the states. Consequently, in a case of this nature, the effect which the act of Congress will have in a state is dependent entirely upon the voluntary action of that state and its inhabitants. In deciding the case, the court took the government's concessions as given, stating, "It is not contended that the General Welfare Clause grants power to regulate agricultural production." The court then agreed with Justice Story's observation that the only thing granted is the power to tax, for the purpose of providing funds for payment of the nation's debts, and making provision for the general welfare. Congress' spending power, even if located in the General Welfare Clause, conferred no regulatory power. The court proceeded to hold the act unconstitutional precisely because it was, in reality, a statutory plan to regulate and control agricultural production, a matter beyond the powers delegated to the federal government. That was because the regulation was not in fact voluntary, as it would lead to financial ruin for farmers who refused the act's benefits. Confirming another aspect of the traditional doctrine, the court held that even the purely voluntary consent of private parties could not expand Congress-limited regulatory powers. The challenge to the Social Security Act in Stewart Machine Company v. Davis followed a similar pattern but reached the opposite result based on a different level of perceived coercion. As in Butler, the federal government defended a federal statute. Here, the Social Security Act, by representing that conditions on the grant of federal funds are not regulatory in nature, and are thus within the spending power. Seeking to avoid a repeat of its loss in Butler, the government argued that the program was also not regulatory in fact, because it did not coerce states to take or refrain from taking any actions. This time, the court agreed with the government, finding that the act was not coercive, and thus did not go beyond the bounds of Congress' spending power. Then, in rejecting a federalism challenge to the measure, the court observed that once the state accepted the federal conditions, it was bound with even lesser force than an ordinary contract. The state was still free, without breach of an agreement, to change her system overnight. No officer or agency of the national government could force a compensation law upon her or keep it in existence, nor could they supervise or control the application of the payments. The court again demonstrated its adherence to the traditional view in Oklahoma v. Civil Service Common. There, the U.S. Civil Service Commission determined that an Oklahoma highway commissioner had violated the Hatch Act, pledging to withhold a portion of the state's highway grants equal to 2 years of the commissioner's compensation if the state failed to remove him. Oklahoma challenged the commission's order and the act on which it was based as an illicit attempt to regulate the state's internal affairs. Citing Mellon, the court held that the act was valid because it did not directly regulate the state, which had adopted the simple expedient of not yielding by refusing to remove its highway commissioner. Thus, to defend these spending programs in the first half of the 20th century, the government relied on the long-settled understanding that the power to spend carries with it no sovereign legislative power to create rights and duties. To the contrary, the government represented that these programs had the binding force, at most, of contracts. They did not preempt, nor did they bind states with the force of law. They merely spent federal dollars upon conditions, the violation of which entitled the government to cease further payments. The court took this position as a given, and the contractual nature of spending conditions is precisely what saved them from constitutional challenge. In sum, the historical record is clear and consistent on a critical proposition. The spending power is the power to spend only. Any duties imposed by regulatory legislation, and any correlative rights secured by law, must find their source in one of Congress' enumerated powers or the legislative powers of the states. Congress' spending power cannot secure rights by law. The contractual nature of spending conditions was taken as a given until the second half of the 20th century, when individuals first began to bring Section 1983 suits premised on violations of conditions contained within spending statutes, usually the Social Security Act. From the enactment of Section 1983's predecessor statute in 1871, to the court's decision in Thibodeau in 1980, this court had never held that Section 1983 was available to redress any and all violations of federal legislation. Indeed, there were almost no square holdings concerning the precise scope of the statutory rights vindicable by Section 1983. Perhaps the only such square holding was that of Holt v. Indiana Manufacturing Company, which narrowly construed Section 1983's predecessor statute to refer to civil rights only, making it inapplicable in a suit based on the federal patent laws. The traditional understanding of both the spending power and Section 1983 began slowly eroding in the 1950s, 1960s, and 1970s, culminating in Thibodeau. On the spending power side, the court held in Cannon v. University of Chicago that the spending conditions of Title IX of the Education Amendments created binding duties on private universities, the violation of which could be the ground of a federal lawsuit by a private party. In doing so, the court simply ignored the crucial difference between restraints accepted as conditions of funding and restraints imposed by virtue of a legislative power. And, on the Section 1983 side, court had considered a number of suits against state officials for violations of the Social Security Act, without analyzing their cognizability under Section 1983. The stage was thus set for Thibodeau to discard nearly 2 centuries of settled spending power doctrine by holding that federal spending conditions secure rights by law, ignoring both the contractual nature of spending programs and the enforcement power-based understanding of Section 1983. Thibodeau declared that the plain language of the statute undoubtedly embraced respondents' claim that the state violated the Social Security Act. The centerpiece of the court's opinion was its imprecise framing of the relevant question, whether the phrase "and laws," as used in Section 1983, means what it says, or whether it should be limited to some subset of laws. After framing the issue thus, the court reasoned that nothing in the legislative history compelled limiting the term "and laws" to civil rights laws enacted under the Reconstruction Amendments. But the court's opinion completely missed the deeper conceptual question of whether spending power statutes can ever impose obligations, and thus secure corresponding rights, with the force of federal law. As explained at length above, the limited nature of the spending power dictates a negative answer. A contrary understanding would transform the terms of federal-state agreements into binding regulations of state entities by federal law, violating the constitutional prohibition against directly regulating or commandeering the states. It took less than a year after Thibodeau for the court to realize the constitutional difficulties with imposing affirmative obligations on the states pursuant to the spending power, and to take the first step toward ameliorating the problems with Thibodeau. In Pennhurst, the court held that a provision of the Developmentally Disabled Assistance and Bill of Rights Act, a conditional spending act, could not be enforced against a state entity under Section 1983. The court first held that the provision could not be considered as enforcement legislation under the 14th Amendment. The court then explained the fundamentally different natures of legislation under the Reconstruction Amendments and legislation enacted pursuant to the spending power, the latter of which is much in the nature of a contract. In return for federal funds, the states agree to comply with federally imposed conditions. Consistent with the traditional position, the court also explained that in legislation enacted pursuant to the spending power, the typical remedy for state noncompliance with federally imposed conditions is not a private cause of action for noncompliance, but rather action by the federal government to terminate the funds to the state. Ultimately, because the Pennhurst Court determined that the provision at issue was not intended to secure rights by imposing obligations on states, it did not need to confront the constitutional problem created by TIBUTA. Nonetheless, Pennhurst both recognized the problem and pointed to the solution: a return to the traditional contractual understanding that itself flows naturally from the limited nature of Congress' spending authority. Without that understanding, however, it is unavoidable that spending conditions that impose substantive obligations on the states with the force of federal law are unconstitutional. As shown above, the federal spending power is nothing more than the power to spend. It neither contains nor implies any sovereign regulatory power to legislate rights and duties with the force of federal law, and the regulated party's consent cannot change that conclusion. The contractual nature of the spending power was essential to the government's defense, and this court's approval of far-reaching spending programs. The program survived only with that traditional understanding as a premise. The federal government and private litigants cannot now discard that understanding to argue that such programs impose obligations directly on the states that are enforceable against state and local officials under Section 1983, without running headlong into the anti-commandeering doctrine and long-recognized limitations on the federal spending power. By holding that FNHRA creates rights enforceable under Section 1983, the majority creates a grave constitutional problem that cannot be brushed away with a mere incantation of TIBUTA. As explained above, spending power legislation cannot secure rights by law. Conditions on a state's receipt of federal funds are effective, not by virtue of federal law, but by dint of a federal-state agreement. The very constitutionality of such conditions depends on their eschewal of securing rights and imposing concomitant obligations on states. The line from Mellon and Butler to TIBUTA, to this case, amounts to a constitutional bait and switch that cannot continue to be glossed over or ignored. In holding that spending conditions are not merely contractual, but can directly impose obligations on the states with the force of federal law, the court unravels the very rationale for their constitutionality. Either conditions in statutes enacted under the spending power are in the nature of contract terms, and do not secure rights by federal law, or they are unconstitutional because they exceed the spending power and illicitly commandeer the states. The consequence of the majority's rejection of the contractual understanding is not that spending conditions are enforceable under Section 1983. Rather, it is that they are unconstitutional. It is well past time for this court to re-examine TIBUTA and the nature of Congress' spending power. Justice Alito, with whom Justice Thomas joins, dissenting. I agree with the court's understanding of the high bar required to bring an action under 42 U.S.C. Section 1983 for the violation of a federal statute, but I disagree with how that standard applies in this case. In my view, while respondent has established that the Federal Nursing Home Reform Act, FNA, creates individual rights, petitioners have established that relief for the violation of those rights under Section 1983 is foreclosed by the remedial scheme in the Act. The majority and Justice Barrett correctly identify the plaintiff's burden under Section 1983. A statute must unambiguously confer individual federal rights to create rights within the meaning of Section 1983, and Gonzaga sets forth our established method for ascertaining unambiguous conferral. In other words, if Congress wishes to create new rights enforceable under Section 1983, it must do so in clear and unambiguous terms, because the standard demands no less and no more than what is required for Congress to create new rights enforceable under an implied private right of action. I also agree that there is no room for a multi-factor balancing test to pick and choose which federal requirements may be enforced by Section 1983, and which may not. None of this is new ground. We have previously held that Gonzaga plainly repudiates the ready implication of a Section 1983 action that our earlier decisions exemplified. The two NRA provisions that respondent invokes demonstrate what it takes to satisfy this demanding standard. First, the Act mandates that a nursing facility must protect and promote the rights of each resident, including the right to be free from chemical restraints imposed for purposes of discipline or convenience and not required to treat medical symptoms. Second, the Act protects transfer and discharge rights, precluding a nursing facility from transferring or discharging each resident except in certain circumstances. Both of these provisions explicitly use the term rights to describe discrete and concrete duties that a defined party, nursing facility, owes to a particular individual, each resident. When these features are taken together, they satisfy the standard for determining whether a personal right exists. When determining whether individual rights are enforceable under Section 1983, I again see much common ground with the majority, and agree entirely with Justice Barrett's explanation of the governing standard. That question boils down to what Congress intended, as divined from text and context. Notably, we have explicitly held that this standard does not demand anything close to the level of incompatibility required to trigger implied repeal. Instead, the question is simply whether the rights created by a later statute may be asserted within the remedial framework of the earlier one. As the majority explains, Section 1983 does not apply where Congress has created an individual right, but also simultaneously given good reason, detectable with ordinary interpretive tools, to conclude that the Section 1983 remedy is not available. Finally, I agree that there is no bright-line rule for when a statute evidences an intent to preclude Section 1983 relief. Courts should consider a wide range of contextual clues, like enforcement provisions that government officials can invoke, and any administrative remedies that the statute offers. Whatever the context, the more comprehensive the enforcement scheme in a statute, the less likely that it leaves the door open for Section 1983 suits. After all, when a statute provides its own comprehensive enforcement scheme, the requirements of that enforcement procedure may not be bypassed by bringing suit directly under Section 1983. When all is said and done, my disagreement with the majority is thus narrowly focused on how this standard applies to this case. In my view, NRA forecloses a private cause of action even though it admittedly creates substantive private rights. The Act creates a reticulated remedial regime that both balances federal and state enforcement and channels disputes through that regime. Allowing Section 1983 suits will upend this careful balance. Consider the remedial provisions that the Act provides. When federal officials find that a nursing home does not comply with NRA, the Act enumerates certain limited remedies they can pursue, such as withdrawing federal funding and imposing civil penalties in an amount not to exceed $10,000 for each day of noncompliance. NRA obligates states to establish certain remedies for noncompliance, including civil penalties, but otherwise leaves them free to specify criteria as to when and how each of the required remedies is to be applied, the amounts of any fines, and the severity of each of these remedies, to be used in the imposition of such remedies. It also empowers states to provide for other remedies as they see fit. Finally, the Act provides special rules where state and federal officials do not agree on a finding of noncompliance. By specifying limited remedies for federal authorities and tasking states with otherwise determining the consequences for violations, the Act creates a clear division of authority that ensures states retain their historical control over nursing home regulation. Allowing Section 1983 suits will upset this balance by allowing any plaintiff to demand damages regardless of the remedial regime that states establish, pursuant to their explicit authority under the Act. Moreover, whenever a plaintiff files suit, the determination about noncompliance will be taken away from federal and state authorities and given to courts, and because the remedies offered under Section 1983 will often dwarf the relief available under FNHRA's reticulated balance of remedies, Section 1983 will swallow the centralized state and federal review mechanisms the Act imposes. The exclusivity of NRA's enforcement regime is buttressed by the grievance remedy NRA gives to nursing home residents. Residents have the right to voice grievances with respect to treatment or care, and the right to prompt efforts by the facility to resolve grievances. States, in turn, are obligated to investigate complaints of violations of requirements by nursing facilities and to take enforcement actions to correct those violations. This grievance process dovetails neatly with NRA's centralized enforcement regime, because it funnels private complaints to the same state authorities that the Act tasks with enforcement. Indeed, respondent in this case wielded FNHRA's grievance process to obtain relief for both of the rights petitioners allegedly violated. But because FNHRA's remedies are more limited than the direct judicial highway that Section 1983 offers, it is hard to see why anyone would use them in the future. The only textual evidence the majority can identify in response to this tailored remedial framework is FNHRA's saving clause, which states that the Act's remedies are in addition to those otherwise available under state or federal law. But this provision only begs the question whether relief under Section 1983 is otherwise available. We have recognized as much when holding that a materially identical saving clause did not authorize implied remedies under a separate remedial provision. And in the Section 1983 context, we have similarly held that saving clauses do not refer to a suit for redress of a violation of the statute at issue. These results are understandable. There is a considerable difference between preserving existing remedies for conduct that happens to violate other laws, and providing a one-stop remedy for the precise provisions in a statute. The latter interpretation runs against a century of holdings that a statute cannot be held to destroy itself through a saving clause. Conversely, concluding that NRA may be enforced only through the statute's express remedies, gives full effect to Section 1396 RH8 because the claims available under Section 1983 prior to the enactment of the Act continue to be available. In short, allowing a plaintiff to circumvent FNHRA's administrative remedies would be inconsistent with Congress' carefully tailored scheme. I would thus hold that the Act precludes enforcement under Section 1983 and reverse the judgment below. I therefore respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.